Hello and welcome to this second video of 3 dealing with negligence. In the first video we considered a duty of care, and in this video we're going to consider breach of the duty, and in the last video we will consider the remaining elements of causation, defences and damages. So this is how it fits into the overall structure then in the A, B, C, D, D for negligence. And in each video, we're going to look at this 10-mark scenario from the AQA exam in 2022. You can see this is worth 10 marks. You may focus in on a particular aspect of negligence for 5 marks. And negligence also features in the longer 30-mark scenarios, and we'll look at an example of one of those at the end of the video. So breach is in 2 parts. Firstly, you need to set the standard required of the defendant, how much care should they take, and the amount is what a reasonable person carrying out the activity concerned would do. Then you need to assess whether that standard has been reached using the 4 risk factors, which is a little bit like carrying out a risk assessment. And if the defendant has not reached the standard of a reasonable person carrying out the activity, then they're said to be in breach. So in negligence, you are not having to be overly cautious and you shouldn't be overly careless. And that's why we have this objective standard. Have you undertaken the activity to the standard of a reasonable person? And that comes from the case of Blythe and Birmingham Waterworks. And in that case, the claimant's house was flooded because a water pipe maintained by Birmingham Waterworks froze and then burst, flooding her house. But in Blythe, they said that the weather conditions were so extreme, no reasonable waterworks would have guarded against it. And that meant they had acted as a reasonable water company, and so they were not in breach of their duty. So sometimes you will find that there is a higher standard, and that is the higher standard must be reached by a professional. You have to show the same degree of skill as a competent member of that profession. So in Bolam and Frion Hospital, it was the standard of a reasonable professional doctor, and that is something that can be applied to any professional. You'd have to reach the standard of a professional accountant, a professional lawyer, a professional teacher, etc. A lower standard is owed by children, and in Mullin and Richards, in the case about the ruler fight, the child was judged against the standard of a reasonable 15-year-old. Look out for learners in the exam. These commonly occur, and the test is that of the reasonable person. Because it's objective, learners are treated no differently than those with experience. So the defendant in Nettleship and Weston had only had 3 driving lessons, but she was still required to reach the standard of a reasonable driver. And whilst that may seem harsh at first glance, there are policy reasons why we require people to reach that standard even if they are learners. And you'll know that, of course, that learner drivers do have to have insurance. And you'll see in the exam you might have beginners or beginner windsurfers, trainee nannies, people who are still at college, people who have never done something before. And you need to say that no allowance will be made for that and that they will have to reach the standard of a reasonable person. If any of these things, the professional standard, the child or the learner is not relevant, you don't need to mention them in the scenario. So if we look at the scenario from the exam, Candy has to reach the standard of a reasonable driver driving in the rain. You don't need to say now whether you think she has or not. You shouldn't conclude at the start. You should conclude when you've done the risk factors, because we're going to use those to assess whether she has reached that standard. So the first risk factor that we're going to consider is likelihood. It's likelihood of the potential harm risked. Note here the spelling of likelihood, it's got no Y in it. And also the word potential, because what we're looking at is what is the potential harm, how likely is potential harm. We're looking into the future. So we're not looking at what did happen, we're looking at what could happen. The greater the likelihood of harm, the more care that is needed. And in Haley and LEB, harm was caused by digging a hole and leaving a tool in front of it. And in that case, the court said that harm was likely as 1 in 500 people in London were blind or partially sighted. So the second risk factor is seriousness, and this is again the potential seriousness of the harm risked. The more serious the potential harm, the more care that is needed. So if, for example, I'm carrying a baby, I need to take more care than I would carrying a sack of potatoes, as the harm would be more serious if I drop the baby. So this factor takes into account the characteristics of the claimant, and a higher standard is expected if the defendant knows the claimant is vulnerable, which would mean that the harm would be serious. And that's what happened in Paris and Stepney, because the claimant only had one good eye and lost his remaining sight completely when he was not provided with goggles. So the potential harm here was very serious, complete blindness, and the employers were found to be in breach. Note that in a scenario, harm may not be likely and you may not think it's serious, and you should say that and then give your reasons why. The third risk factor is cost and practicality, but this is a shorthand really. You need to be asking whether there is a cost involved in preventing the risk, i.e. should someone have done training or had lessons or whatever it is and had to pay for them, and whether it would have been practical or possible to avoid the risk. So the amount of time and money you spend should be in proportion to the risk. And we can see that in Bolton and Stone, where a woman was hit by a cricket ball that was hit out of the ground. The harm wasn't likely, as the ball had only been hit out of the ground 6 times in 30 years. So that was a very low rate. And it meant that the 17-foot fence around the ground was a reasonable precaution, and the club had not breached its duty of care. Had it been a much more frequent occurrence, it may have been that they would have had to have done something else. But in this case, to have actually made the whole thing completely safe, they would have had to have spent an awful lot of money, and they had done what a reasonable cricket club would in that situation. So they were not found to be in breach. The last risk factor is social benefit, and this includes acting in an emergency. So if by taking the risk there's a potential benefit to society, or you are acting in an emergency, then you may owe a lower duty. And this is shown by, for example, if I was pulling someone from a burning car, I might not be taking that much care because I'm trying to get them out of the car, and I might tear their clothes, but I would owe a lower duty in that situation as I'm acting in an emergency. And that might mean that there's no breach. So this was shown in Wharton, Hertfordshire County Council, where the court held that rushing to save the life of a motorist was worth the risk of injuring a fireman by not carrying the equipment properly, and the council had not breached their duty of care. So then you can conclude breach at the end once you've considered the 4 risk factors. And this is a balance because they may not all point the same way. So whilst harm may be likely and could be serious, it may be that there was a social benefit to what was going on. So you need to balance it out and decide overall whether you think there is a breach. So that's what we're going to do for the Candy scenario here. So remember, Candy was driving whilst distracted by her mobile phone. That was the negligent act. And as a result, Jake suffered a broken leg. So applying the risk factors here, it's worth saying, telling the examiner why you're using them. The risk factors are used to assess whether the defendant has reached the standard. Here, harm is likely if you drive in the rain whilst distracted by your phone, as you are likely to cause an accident. More care is needed. So say why you think harm is likely. The potential harm could be serious, as if you're distracted, you could crash into another road user and cause serious harm. More care is needed. Note there that you're not saying here harm could be serious as Jake has broken his leg. You are looking ahead to what could happen. You're not looking at what did happen. There's no cost involved in driving without looking at your phone, and it would have been practical. It would have been possible for Candy to do that. So she's not taken steps in proportion to the risk. And lastly, there's no public benefit to taking the risk. And you can see that the cases here are in brackets as they are being used as legal authority to support your propositions. And then you can conclude at the end Balancing the risk factors, Candy has not reached the standard of a reasonable driver and is in breach. So just a few final points. Something called res ipsa loquitur used to be in the exam, but since the exam changed in 2019, it's no longer examined. It was about obvious cases of negligence, but you don't need to worry about it. We're going to do causation, defences and damages in the third video. And this is an example, as I mentioned at the start, of negligence appearing in a longer scenario. So this is a question 11, so it has a 7-mark part, which is about theory of tort law in this case. It could be about English legal system, and it can be about theory, and it can be about the nature of law. This is 7 marks on assessing how courts decide whether a duty has been breached. So that leaves 23 marks for the rest of the scenario, which is a mixture of negligence and vicarious liability. So this is probably a good one to go back to when you've studied those topics and have a go at it. So I hope that's been useful. Thank you.